the claimants fail to satisfy the tests laid out in the Judicial Authority Law, Article 5A, subsection B and C, it cannot be pinned that the DIFC jurisdiction does govern over this disputed trade. Thus, due to the aforementioned reasons, I urge the court to consider the lack of jurisdiction in this case and allow my client, Mr. Payne's appeal. Thank you.
Thank you very much, Nabia. I don't have question. I don't know if my co-judge has question for you.
No questions at this time. Thank you.
Thank you. So I think we can, thank you very much. I think we can proceed with the senior respondent for Middlesex University Team M.
Good morning.
Good morning.
Good morning. May it please the court, counsel, my name is Ikra Islam, and I, with my learned junior, Fazlullah Muhammad, will be representing the respondent, Ms. Raz Rani. With the permission of the court, the respondent is responding to the appeal of the Digital Economy Court by the appellant to disprove the appellant's claims and to prove that the court dismissed the claims on challenging the court's grounds challenging the court's jurisdiction, I apologize, and presented a judgment on the right points of law. The respondent will respond to two grounds appealed by the appellant. First, the Digital Economy Court of the DIFC has jurisdiction over the claim of respondent under Article 5A, 1, subsection B and D of the Judicial Authority Law, Dubai Law number 12 of 2004. And the second ground, which will be addressed by my junior, Fazlullah Muhammad, which states that the court correctly concluded that the appellant, a reasonable trader with knowledge of the circumstances surrounding the transaction, would have concluded the disputed trade was the result of an error sufficient to satisfy Article 37(1)(a) of the DIFC contract law. Presenting the first ground of appeal, in the first instance court did not err in concluding that Clevity operated a distributed ledger with a node in the DIFC, which gives the DIFC court jurisdiction over the claim of Ms. Raz Rani against Mr. Payne under Article 5A, 1B of the Judicial Authority Law. Your Honors, would you like the respondent to present the facts of the case according to their interpretation of the events?
Yes, please go ahead. For me, yes. Karen?
Yes, thank you. Thank you.
Thank you.
Both parties trade on an online trading platform called Clevity in cryptocurrency YAPL. This online trading platform uses a distributed ledger which is hosted across hundreds of digital nodes in different countries. One of the nodes is on the server in the DIFC. The users on the Clevity platform must maintain a cash of US $50,000 in their accounts. The platform Clevity allows users to undertake algorithm trading. Trades can be concluded without human involvement. The appellant's program called Beta is created to offer to sell YAPL at the average price of all sellers and in absence of other sellers at an inflated price. The respondent's program Alpha buys YAPL at an inflated price. There was an error on the Clevity platform during regular maintenance on 10th June 2022, which caused the respondent to buy at a price 250 times greater than the market price. Clevity automatically settled the disputed trade and made relevant transfer of funds while the parties were asleep and unaware of the events on the platform. It is to be noted that the parties did operate from different locations as the Sultanate of Oman and Dubai. The transaction on the database still occurred, and as nodes process and witness every transaction, the node in the DIFC did the same, hence proving the relevance of a node. Moving to my submissions, the first instance, the court did not err in determining that the DIFC has jurisdiction over the respondent's claim, as the contract was concluded in the DIFC, as concluded on Clevity's distributed ledger system. The node in the DIFC gives jurisdiction as a distributed ledger is defined as an asset database that can be shared across a network of multiple sites, geographies, or institutes and nodes. as shown under the report by Government Office for Science called Distributed Ledger Technology Beyond Blockchain, year 2016 on page number 5. It is also mentioned on Dubai Financial Services Authority under the DIFC. Node on the network is meant as a processor of information for the network of nodes. Transactions are added to the database in blocks and is reviewed by nodes, again using the same source as I mentioned above. Now referring to a case, the case of Zippo Manufacturing.co against Zippo.com, where the court stated that it has personal jurisdiction over a website originating in a different territory if the website is accessible to internet users in the court's territory. Hence, Clevity's node in the DIFC is sufficient evidence for the DEC to conclude that the disputed trade contract was concluded in the DIFC, because the node serves not just as a medium of information exchange, but also the location in the DIFC for finalization of contracts. Also to mention against the co-counsel, if presence of a node does not give jurisdiction, nodes being worldwide would result in no jurisdiction at all for the disputes. Moving on to proving this further with second point, which is in regards to the interpretation of Article 5A(2) of the Judicial Authority Law. The court has determined the meaning and scope of Article 5A of the law and Article 20 of DIFC Law number 12, 2004. The law states that the DIFC Court of First Instance has original jurisdiction of the Judicial Authority Law to hear the following: civil or commercial claims and disputes arising out of or relating to a contract or promised contract, whether partly or wholly concluded, finalized, or performed within the DIFC, or will be performed or is supposed to be performed within DIFC pursuant to express or implied terms stipulated in the contract. To note specifically, Part 2 of Article 5, which states that DIFC has jurisdiction over the contract between claimant and respondent, as a node in the DIFC does substantiate the contract being concluded. This is shown in the case of Lidham against Oxford Investment, where the reasoning of column judge was applied. From the case of Khalil against Shua Capital, a DIFC case, it stated that the jurisdiction of the DIFC court at first instance has original jurisdiction in line with Article 5A(2) over commercial cases and disputes. The article gives a requirement that the transaction shall be related to DIFC activities, which simply means that the transaction should have been as a result of a particular commercial activity carried on in the DIFC. This was established in the case of Al-Khurafi against Bank Sersan 2011. In regards to Part 5 of the DIFC Law number 10 of 2005, which is applicable for the interpretation of Article 5A(1)(b), the test prescribed under Article 16(5) of the DIFC Law regarding the establishment of jurisdiction in commercial contracts must be applied, which states if the parties do not specify the governing law of a contract, the contract shall be governed by the law of the DIFC. In conclusion, the presence of Clevity's node in the DIFC does substantiate the first instance court's argument of the contract of the disputed trade being concluded in the DIFC. The respondent requests the court to dismiss appellant's appeal on the reasoning presented by the respondent. Thank you.
Thank you, counsel. Just wanted to revisit 2 points from your argument. One being the comparison or the analogy that you drew between the cases regarding the access to the website that were selling products and the node. Did I understand that correctly, or?
Yes. So the reason why I used a case which was in regards to a website, I understand that these both are very different because here the contracts are being settled, but that's a website which is accessible to all the people around the world and they are selling products. So, but the reason why I'm using this specific website is this specific case is because it's promising to the jurisdiction part, which is exactly the issue at hand. That is what I wanted to prove in that regard.
Yes, but what is the principle from the website case, or the legal principle if we can call it, on jurisdiction that applies to the node. So you're saying the fact that the website was accessible from a certain country where people were able to go and buy products and have them delivered also within their territory is sufficient to create a jurisdictional link.
Exactly.
Were the
Yes.
parties in this case aware that the node is is located in the DIFC?
Yes, in my opinion, yes. According to the respondent, both of them were aware where the nodes are located.
Okay.
Since because nodes are a part of different geographies around the world, and like I said, I've already mentioned, if nodes do not point to jurisdiction, then there won't be any way to actually establish jurisdiction at all for any disputed for any dispute. So that's one of the points here as well.
Okay, so but this isn't clearly stated in the fact pattern of the Moot problem that the parties are aware. This is the respondent's characterization of the facts that there was awareness
Exactly. Yes.
with respect to this node. And then other than, do we know that this node specifically played a role? Because in one of the cases that you were citing, was it Alibaba, I think?
No, the Alibaba is not from my side. I think it's from the appellant side.
The appellant side.
Right,
Okay.
yeah, they cited
I'm not
Alibaba.
sure. I'm not sure what case you cited, but you did cite a case where the court, where you mentioned that the court in that case was aware of which node was involved in processing a particular transaction.
Yes, that was the case of Lidham against Oxford Investment and the Khalil against Shua Capital, DIFC case.
Okay.
Yeah.
And so in that case, there was a factual investigation as to which node played a role in processing the transaction.
No, the main part from that specific case was that even though the transactions are, as long as the transactions are related to DIFC activities and under the DIFC, there will be a jurisdiction. That was the main claim from that case.
Okay, so the case said simply as long as there's DIFC activity, and then you related that to
our point, yes.
On the node, but we don't know factually whether this node was actually involved.
Yeah, like I already mentioned even the definition of the node itself. When nodes process, they record everything, every transaction happening. So even the contract being concluded was on that node, which is like on every node wherever it's present. So that was the main argument here. If that's clear. Yeah.
And then with respect to other than the node being there, are there other arguments as to why this is the right jurisdiction?
Under Article 5A itself. So if it states that if both parties do not have, they haven't decided on a jurisdiction themselves, then the DIFC jurisdiction will apply. That's just in the law itself. So that's our main argument.
Thank you, counsel.
Yes.
That's very clear. Thank you. No further questions from me at this time.
Neither for me. So I think we can proceed with the rebuttal from the senior appellant.
Thank you so much. I'd like to include 3 submissions for my rebuttal. First, I'd like to bring to the court's attention that distributed node ledgers merely store information, and there is no way of determining which node stores information. I would like to use an analogy. 2 parties can conclude a crypto trade in Brazil and Portugal, but the information of that trade can be stored in a node in Turkmenistan. This does not mean that Turkmenistan has just jurisdiction over the trade concluded between parties living in Brazil and Portugal. The main rise of crypto trading was due to the fact that it was so decentralized that no common law jurisdiction of the world could readily govern over it. And because Clavity does not specify their method of nodes storing information, which nodes store information and to what extent, it cannot be completely proven that the information of the transaction between my client and Ms. Rasrani was stored in the DIFC node. Secondly, I do not agree with my learned respondent's mention of the case of Al-Khufari versus Bank Sarsen, as the fundamental aspect of banks is that they are centralized to a common jurisdiction. Whereas for cryptocurrency, the basis of crypto trading, as I mentioned before, is that it's decentralized. And due to this, as I mentioned in my argument before, crypto being a novel legal scenario, it requires significant legal improvements to set out tests that apply jurisdictions over crypto transactions. Mere storage of information in a node cannot be sufficient to prove a certain country's jurisdiction over a trade. Also, Article 5AD, which says that if both the parties do not agree to a written jurisdiction, the IFC courts can't exercise jurisdiction, also does not apply, because in this case, the minute Ms. Razrani issued proceedings in DIFC courts, my client contested that jurisdiction. That means he rejected the jurisdiction of the IFC being applied over this disputed trade. Hence, it fails to satisfy any article mentioned, any subsection mentioned under Article 5A of the Judicial Authority Law. Thank you.
Thank you. I have a question for you. If it's not the IFC jurisdiction that can be applied to this specific case, which jurisdiction, according with the facts and according with what you wrote in your jurisprudence, in the jurisprudence that you consult, which jurisdiction you would invoke in this?
Thank you so much for
if it's not the IFC. Thank you.
Thank you so much for your question. I would like to argue that, first of all, the DIFC jurisdiction fails to apply, which due to my speech. Second, to prove that one specific jurisdiction applies to this transaction, we would like to go into certain complete in-depths of which node stored that transaction. Second, where Clevity operates from. Thirdly, where Clevity functions from. Fourthly, if there is a main ledger inside of Clevity's workings that store all of these sorts of transactions. Because due to the fact that cryptocurrency is completely online and completely decentralized, and distributed ledgers only allow users to check information of the transactions, and this is why it poses certain difficulties in law governing over it. So in order to apply a certain country's jurisdiction, it would require a lot of legal, jurisdictional, and financial analysis about where exactly the trade was concluded, at what point, at what hour, in which country the money was being transferred from what networks was the crypto being traded through. So in order to apply, and so I would like to summarize my answer by saying, in order to apply one certain jurisdiction, it would require a lot of legal, financial, in-depth analysis, which I think the IFC and a lot of common law jurisdictions of the world lack, because they have not faced a lot of crypto jurisdictional challenges.
Counsel, just to point out that you had said earlier that there is no way to know which node was involved and whether the Dubai node was involved. So, I mean, I think my co-judge asked a very relevant question. If not, I mean, yes, this is a novel legal scenario, as anything related to cryptocurrency still remains in the world, but we do have a real world dispute. And we have very serious financial consequences that have taken place, and we have, two people who need legal relief. Where can they go? Where else can they go? I mean, the court needs to be comforted that they will seek and be able to obtain justice somewhere. So,
thank you, sir.
What other legal avenues, credible legal avenues, are there to attach jurisdiction elsewhere?
Thank you for your question. In my perspective, I would like to review this transaction as a contractual transaction, and I would like to use the English court's approach of offer and acceptance. In the English courts of approach, they view as acceptance of a contract provided when the acceptance is received by the person who was offering. So in my case, when Mr. Leith Payne was offering to sell cryptocurrency at a very inflated price, and when Ms. Razrani's program accepted that, and the money was debited from her account to his account in the Sultanate of Oman, I would like to use the approach that when the money was debited from her account to my client's account, that is when the acceptance was delivered to my client that this trade has been made. So if we use that approach, in my perspective, the Sultanate of Oman should be able to govern this disputed trade, as he was the one who offered to sell Yapple at this price, and Ms. Razrani's program accepted that price and debited that money. And the minute he received that money in his bank account, the acceptance was concluded and a contract was formed, and hence why the Sultanate of Oman should be governing this dispute.
Thank you. No more questions from me at this time.
Thank you so much.
Thank you. Fine for me as well. Thank you. I think we can proceed now with the junior counsel, the appellant. So please go ahead. Thank you.
Good morning, and may it please the court, as introduced by my learned senior, Ms. Nabiha Khan, my name is Mr. Momin Khan, junior counsel for the appellant, Mr. Leith Payne. As stated by my learned senior, I will be addressing the second round of appeal. For the benefit of the court, may I reiterate the ground of appeal and relevant facts that I will be contending with?
Sure, please. Thank you.
Firstly, my client's argument. Mr. Payne argued that there could be no relevant mistake within Article 37 of the DIFC contract law. Mr. Payne said that even if Ms. Rani had made a mistake, when he programmed Beta, he did not make the same mistake as Ms. Rani or cause her mistake, and he did not know and could not have known about Ms. Rani's mistake, and so there could be no grounds to avoid the disputed trade. Secondly, the court's assessment was that it did not need to examine the state of mind of the programmer when designing the program. It was held that in the court of first instance that it was sufficient that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that disputed trade was the result of an error. In reaching this conclusion, they cited Lord Mans from the case of Coin Private Limited and B2C2 Limited reported in the 2020 Singapore International Court of Appeal on page number 2. Your Honor, with these facts laid out, I will now begin with my submission that the judge in the court of first instance erred in his application of law regarding Article 37, Section 1, subsection A. Firstly, I would like to discuss that the case of Coin Private Limited and B2C2 Limited reported in the 2020 Singapore International Court of Appeal on page number 2 can be discussed in two parts. The first being the arguments put forth by it as the facts of it may be beneficial to our current situation. And second, Lord Mans's judgment as applied by the court of first instance. The facts of the case are quite similar, so may I reiterate them for the benefit of the court?
Yes, please. Thank you.
Coin Private Limited was a trading platform on which an error had occurred. This resulted in the algorithms of the parties involved, namely B2C2 Limited and others, concluding trades at a highly inflated price. The trading platform had reversed the trades after taking note of them and realizing they were caused by an error on their platform. B2C2 Limited brought a claim against them to recover the riches that they gained from the error on the grounds of breach of contract or breach of trust. Breach of trust is not relevant to my submission, so it will not be discussed, but the court judge did rule in their favor. Coin filed an appeal, but their appeal was dismissed, leading to this case before the Singaporean Court of Appeal. The majority in this case ruled that when the deterministic algorithms were doing the trading in respect of their programmers, the state of mind of the programmer must be analyzed from the creation of the algorithm until the conclusion of the contract in question. Mr. Payne's state of mind when designing Beta could be subject to much speculation. However, it must be noted that when the programmers of B2C2 had designed their algorithm, they did not design it to benefit from volatile market conditions. The parameter to conclude a trade at an inflated price was to ensure that the algorithm did not break and stop working in extreme market conditions. It can be argued that this was Mr. Payne's intention as well, as he could not have realistically predicted an instability in the market that would have resulted in his benefit. If Mr. Payne did not become aware of this possibility at any time prior to the conclusion of the contract, there is nothing that can be said regarding his knowledge of the mistake. This conclusion means that Mr. Payne did not make the same mistake as Ms. Rani, as he was just trying to ensure the continuing function of his algorithm, and he could not have caused her mistake or known of the mistake, as the trade was concluded by deterministic algorithms in the complete absence of human input at the time of the formation of the contract. I would like to elaborate further on this point in my second submission regarding Coin. For my second submission regarding this case, I would like to bring to the court's attention that Lord Mans was providing a dissenting judgment, and his approach was criticized by the majority for a number of reasons. Firstly, Lord Mans's approach was scrutinized as being wholly artificial because it attempted to claim the trade was concluded in a hypothetical on-the-floor meeting and not through pre-programmed algorithms. Just a moment, there's some background noise. Can I just sort that out? My apologies, an alarm was going off in my background. As I
No
was
problem.
saying, Lord Mance's approach was scrutinized as being wholly artificial because it attempted to claim that the trade was concluded in a hypothetical on-the-floor meeting and not through pre-programmed algorithms, and that the final contract was entered into on terms that were not within the program parameters of the parties' algorithms. The majority in the Court of Appeal in this case argued that the parties had chosen to do their trading through algorithms, and it follows that any trades concluded by said algorithms would not be mistaken trades so long as they were concluded within the parameters set by the programmers. As I've already established, Mr. Payne did not know of or cause Ms. Rani's mistake in this case. The disputed trade was concluded by her algorithm within its preset parameters, and Mr. Payne's algorithm only sought to retain continuous function with its deep price parameter. It follows that the approach adopted by the majority should be considered more apt in this case. It is also important to note that the Singaporean court was applying the equitable doctrine of mistaken equity. No such approach exists in the English courts or the DIFC courts, and this statement can be supported by the paragraph 90 of the Coin case found on page 238 to 239 of the Appellant Court Bundle. For my second submission, I would like to bring to the court's attention the case of Smith and Hughes, reported in volume 6 of the 1871 Queen's Bench Law Reports on page number 597. This case has provided a long-standing authority for the doctrine of unilateral mistake at common law and serves as a much stronger basis than the doctrine of unilateral mistake at equity. May I state the facts of the case for the court?
Yes, for me, thank you.
In this case, the defendant mistakenly assumed he was buying old oats from the claimant and refused the contract once he had realized the contract was for new oats. The plaintiff sued the defendant racehorse trainer for a breach of contract for the sale of oats. It was held that unilateral mistake may only apply to the terms of a contract, and one party holding a mistaken belief is not enough to void a contract. Your Honor, as I have previously established, Mr. Payne did not make a mistake as to any terms of the contract, and he did not cause Ms. Rani to hold a mistaken belief that he intended to take advantage of. Ms. Rani held the mistaken belief that her algorithm would not lend itself to concluding a trade that would not be beneficial to her, and had taken no countermeasures to prevent such a situation. Mr. Payne, on the other hand, was aware of the fluctuations that occur every so often in the market and had taken preventative measures only to ensure his algorithm would remain online and functional. There was no mistake here as to a fundamental term of a contract, only the mistaken belief of one party that there would never be an unfavorable market condition. It is my contention that under the doctrine of unilateral mistake recognized by the English courts, Mr. Payne should not be penalized for Ms. Rani's unpreparedness under the circumstances of this case. Through my previous two submissions, I have established that the mistake is no fault of Mr. Payne's. However, I would now like to submit that it is in fact Ms. Rani who is entirely at fault for this situation under DIFC contract law. I would like to bring to the court's attention the case of the Crown on the application of Software Solutions Partners Limited and Her Majesty's Commissioners for Customs and Excise, reported in the 2007 England and Wales High Court on page 971. May I state the facts of this case for the benefit of the court?
Yes, thank you.
In this case, the claimants, Software Solutions Partners Limited, were providers of a program that allowed insurance brokers to expeditiously prepare insurance contracts with insurers. The program worked by accepting the input of parameters by the insurer and outputting a contract that fell within those pre-programmed parameters. It was held that even in the event of system error, the insurers would still be legally bound by the contract generated within limits, even if they were temporarily unaware of the resulting contract terms. This software was analogized with parking meters in Thornton and Shoe Lane Parking Limited, reported in Volume 2 of the 1971 Queen's Bench on page 163. The analogy I'm referring to can be found in paragraph 66 of the Software Solutions Limited case judgment on page 128 of the Appellant's Court Bundle. In that paragraph, the court accepted that such a software is similar to the parking meter in the case of Thornton and Shoe Lane Parking, and as Lord Denning had so aptly put it, the customer pays his money and gets a ticket. It can be translated into offer and acceptance in this way. The offer is made when the proprietor of the machine holds it out as being ready to receive the money. The acceptance takes place when the customer puts his money into the slot. These situations are relevant to my client's appeal as the methods of transaction are very similar. Mr. Payne had programmed his algorithm to sell a Yapple at the best available market price, and in the event of there being no best available market price, at a highly inflated price to ensure it remains operational. Ms. Rani's algorithm bought Yapple at the best available price, and consequently, in this case, at the highly inflated price. Ms. Rani's algorithm works similarly to the way an insurer would input parameters into a program and then be bound by the contract that was formed thereafter in Software Solutions Limited. She provided an input and she received an output. Even in the event of an error by her algorithm, she should be bound by the result as the insurers were in Software Solutions Limited. The end result still fell within the program parameters of her algorithm, so it cannot be said that this was a consequence that was entirely unforeseeable. Her input of parameters should indicate full acceptance of the offer made as they were in the ambit of her programming, similar to the case of Software Solutions Limited and the case of Thornton and Shoe Lane Parking. Bearing these facts in mind, I would like to make 2 points for my final submission, one statistical and one legal. Firstly, the manager and writer of the Quantified Strategies website, Odmund Growit, penned an article titled, "What Percentage of Trading is Algorithmic? Algo Trading Market Statistics, Growth, Trends, and Forecasts." In this article, he mentions that a study concluded in 2019 found that 92% of Forex market trading was done by algorithms and not humans. And according to Select USA, a federally backed United States summit held by the US Department of Commerce's International Trade Administration, it was found that around 60 to 75% of all equity trading was carried out by algorithms. It is evident from these statistics that algorithmic trading is no recent phenomenon that took the world by storm. It is a well-established and practiced method of trading globally. With that said, I would like to establish the second part of my final submission by directing the court to DIFC Contract Law Article 37, Section 2, subsection B. The provision states that a party may not avoid the contract if the mistake relates to a matter in regard to which the risk of the mistake was assumed, or having regard to the circumstances should be borne by the mistaken party. Your Honor, I contend that with these statistics in mind, Ms. Rani should not be allowed to avoid the contract with Mr. Payne, as the risk should have objectively been in her reasonable contemplation, and as such is a risk that should be borne by her, the mistaken party. This concludes my submissions for the second round of appeal on behalf of Mr. Leith Payne. Your Honor, on these facts, I request that the decision of the Court of First Instance be overruled and the appeal be allowed. Thank you.
Thank you.
Thank you.
Any questions from my co-judge?
No, I don't have any question. I don't know if you have a question.
I do have some question. I have one question, at least at this time. I just want to go back to the argument being presented with respect to the unilateral mistake. Is counsel suggesting to the court that essentially the legal principles are that when one side makes a mistake on price of a transaction, which is generally considered an essential element of the transaction, that that would not impact consent overall and formation of the contract?
Thank you for your question. Is that all of it?
For now, yes.
Counsel is not suggesting that the price of a contract or a mistake to the price is anything that can't negate consent. While it can, the issue in contention here is not the price of the contract, rather the mistaken belief that Ms. Rani held that there would never be an unfavorable market condition. She was not aware that a trade would even be in conclusion at the time of the conclusion of the contract. Both parties were asleep. So it must be assessed what the state of mind of hers was before, like prior to the conclusion of the contract, from the beginning of the creation of her algorithm. If it wasn't within her contemplation that there would one day be an error in the market or an error on the side of platform when she created her algorithm, then that is a fault of hers entirely. As we all know, crypto is a very volatile trading asset. So I don't believe that Mr. Payne should be penalized for being prepared while Ms. Rani was not prepared for a fluctuation in the market, as I do believe that people lose thousands upon thousands of dollars, pounds, whatever currency, when trading in crypto. And that is just a risk that they assume when they partake.
Just to sort of circle back to that point again, your argument is that Ms. Rani made a mistake in the sense that she was not expecting this market fluctuation that took place. But ultimately, that mistake resulted in her not expecting the price at which this contract was concluded. What do you have to say about that?
So in the case of Smith and Hughes, it was established that holding a mistaken belief that does not form a term of the contract is no fault of the person holding, is no fault of the person who did not have that mistaken belief. In that case, the person contracting thought he was going to be buying old oats, but he was actually buying new oats. That did not make a term of the contract. Similarly, in this case, there was no contract that either party was aware of, only the fact that they endeavored in crypto trading. And as I've established, algorithmic trading is worldwide prevalent. It is prevalent worldwide, and everyone is aware of the risks associated with it and the possible losses and everything. And I do believe that there have been cases such as Coin, for example, where there was an error on the part of the platform. However, that did not make the platform, that in that case, it was decided the platform's error still resulted in a just enrichment of the parties who made money off of that trade, because they did not make a mistake as to any terms. They did not make a mistake as to anything to take advantage of reasonable commercial standards of fair dealing. They only took precautions, and in this case, Mr. Payne took a precaution as well, and he benefited off of it. However, he did not intend to do so maliciously, and he did not intend to do so for any reason besides taking precautions, which I do believe Ms. Rani should have taken as well.
Thank you. Nothing further from me.
Yeah.
Thank you.
Nothing for me as well. Yes, yes. Yeah, I think this is exactly the key of this case, the consent, and the key of all these contract, and the key of this challenge that we have with algorithm and with this kind of contract. If there is nothing to add, I think, yes, we can move to the junior counsel respondent. Thank you very much.
May it please the court, as introduced by my learned senior, I'm Fazlullah Muhammad, appearing as junior counsel on behalf of the respondent in this appeal, Ms. Raz Rani. Your Honors, I will address the second ground of appeal and attempt to convince this court to uphold the decision of the learned judge in the court of first instance, which was based on sound legal reasoning, and conclude that the disputed trade can be voided for unilateral mistake by showing that the appellant had constructive knowledge of the respondent's mistake, and that the state of mind of the programmer at the time of making the program is irrelevant. I shall be making one submission which will elaborate based on statute and case law as to why the decision of the court of first instance must be upheld. Within my submission, I will attempt to prove that DIFC law statutorily accommodates the doctrine of constructive knowledge in unilateral mistake, and how such constructive knowledge can be inferred upon the non-mistaken party. With the court's permission, I shall now begin my submission. Your Honors, the court of first instance did not err in concluding that for the purpose of a claim to avoid the disputed trade for unilateral mistake under Article 37(1)(a) of the DIFC contract law, it was sufficient for the respondent, that is, the mistaken party, to show that the appellant, that is, the non-mistaken party, as a reasonable trader with knowledge of the circumstances surrounding the disputed trade, would have concluded that it was the result of a mistake. In other words, it would be sufficient to show that the appellant, as a reasonable trader, had constructive knowledge of the mistake as opposed to actual knowledge, and thus negating the contention that the state of mind of the programmer is relevant to analyzing constructive knowledge. Article 37(1)(a) of the DIFC contract law provides that a party may only avoid a contract for mistake if, when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded it at all if the true state of affairs had been known, and A, the other party made the same mistake or was also mistaken or caused the mistake or ought to have known of the mistake, and most importantly, it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. Looking at this provision, even though my learned friend contends that the equitable doctrine of mistake is not applicable in this case, it is important to point out that the provision in the DIFC contract law emphasizes on the principles of fair dealing. That's thus, even if there is, if the principles of equity are inapplicable, the principles of fair dealing and the principles of fairness would be applicable based on the DIFC contract law. So based on this provision, it means that the disputed trade can be avoided if the appellant ought to have known of the significant unilateral mistake on the respondent's part. In other words, the disputed trade can be avoided if the appellant had constructive knowledge of the mistake. If your honors would kindly turn over to the highlighted portion on page 22 of the respondent's bundle, it can be seen that a DIFC contract law is based upon Article 3.51a of the UNIDROIT Principles of International Commercial Contracts, which consists of the same language as DIFC contract law. The relevant elaborative commentary, the first highlighted portion on page 24 of the respondent's bundle, clarifies that for a contract to be voidable due to unilateral mistake, the non-mistaken party must satisfy any of the four conditions found in Article 3.51a. For the purpose of this appeal, the relevant condition is the third, that is, the non-mistaken party ought to have had constructive knowledge of the mistake, following which it would be unreasonable and unfair to leave the mistaken party in an erroneous state. The commentary further provides that the test of constructive knowledge is that the appellant's constructive knowledge should be the same as what a reasonable person should have known if they're in the same position as the appellant. Your honors, any reasonable trader who regularly undertook algorithmic trades on the Clevity platform and who had knowledge that the Clevity platform underwent routine upgrades, like the appellant, should have known and would have developed the awareness that the sale of YAPL at 250 times higher than the market rate was an abnormal situation that could only be caused by an unforeseen error, malfunction, or interference, and insisting upon such a sale would put the mistaken party in an unfair position, which is contrary to the principles of fair dealing. Supplementing the aforementioned point and applying Lord Mance's view in Coin Pte Limited and B2C2 Limited 2020, the disputed trade should have been reversed as soon as the appellant, as a reasonable trader, identified that the transaction was caused by an obvious malfunction. This shows that Lord Mance had sound legal reasoning in his judgment, which supplements the provision of Article 37(1)(a) that leaving the mistaken party in an erroneous state would be contrary to the principles of fair dealing, and the disputed trade should have been reversed as soon as the appellant, as a reasonable trader, identified that the transaction was caused by a malfunction. Moreover, and most importantly, and this comes back to the point of freedom of contractual relations and the flexibility and freedom that each party in a contractual relationship exercises, Lord Mance, with regards to this, aptly stated that a computer malfunction should not be given the status of a dominating force that forces contracting parties to abide by a highly unusual and unfair trading situation arising out of the said malfunction, a situation which runs contrary to the reasonable commercial standards of fair dealing. Your honors, it is undisputed that the trading took place through algorithmic platforms, and obviously the parties that undertook trading through such algorithmic platforms had knowledge of the fact that algorithmic trading is prone to certain volatile market fluctuations, which is still acceptable within the limits of fair dealing. However, an unforeseen error caused by the platform, which does not equate to a volatile market, but rather it is a malfunction on part of the platform, is a highly unforeseen situation which the parties did not expect, and such a situation should not force or negate the consent of the parties to hold, or most importantly, negate the consent of the respondent to abide by a situation that is highly unfair and puts her in a highly disadvantaged situation. In supplementing the DIFC contract law, I refer to the British Columbian Supreme Court case of Craig Estate and Higgins, which is found on page 14 of the bundle. Would your honors like a brief overview of this case?
Yes, thank you.
Yes, thank you.
In this case, the court had to consider if an offer to settle entered into by the plaintiff's solicitor under mistaken terms was voidable for unilateral mistake, and whether defendant or his solicitor ought to have had constructive knowledge of the mistake. This is similar to the facts of our case in the sense that the respondent's algorithm, just like the solicitor, had entered into a faulty transaction on behalf of the client on mistaken terms without the input of the client. In this case, it was held by the judge that the defendant ought to have had constructive knowledge, thus justifying the voidability of the contract based on unilateral mistake. It was also held that in a case of unilateral mistake, it would be unfair to allow a non-mistaken party to enforce the contract if it possessed constructive knowledge of the mistake. This decision, along with Lord Mance's reasoning in Coin, is in line with Article 37(1)(a) of the IFC contract law, which states that a contract is voidable if the non-mistaken party has constructive knowledge of the mistake. Your Honors, having established the aforementioned, I shall now address how constructive knowledge is to be inferred in a situation of unilateral mistake. I now refer to the Canadian High Court case of McMaster University and Wiltshire Construction Limited 1971, which is found on page 12 of the bundle. Would Your Honors like a brief overview of the case?
Sure, for me, fine. Thank you.
In this case, the defendant had mistakenly omitted a part of the construction tender which contained a significantly important clause which went right to the terms of the contract, and the court had to consider whether the plaintiff, as a reasonable person and as a reasonable commercial person, ought to have known of the defendant's mistake, and how such constructive knowledge can be inferred on part of the non-mistaken party. Similarly, in our case, a significant term of the contract has undergone a scenario or a situation of mistake, which goes right to the price of Yapple. It was held in this case, applying the locus classicus of Hartog against Collin and Shields, that constructive knowledge on part of the non-mistaken party can be inferred if the mistake would also be obvious to a reasonable person in view of the surrounding circumstances. Your Honors, the aforementioned decision can be adapted to the modern emergence of automated contracts. It is undeniable that the disputed trade took place via deterministic algorithms without human interference, thus preventing any possibility of actual knowledge on part of the appellant. The absence of actual knowledge is the case with any algorithmic trading. So the question that arises now is, how can a situation of mistake be then addressed if there is no actual knowledge? And this points us towards the obvious option of constructive knowledge. Based on McMaster, constructive knowledge can be inferred on the basis that if the appellant was hypothetically aware of the circumstances surrounding the disputed trade, it would have been obvious to him as a reasonable trader who regularly undertook trading on the Cleverly platform that a mistake had occurred and the contract could not be reasonably concluded on the mistaken terms. This can be supplemented with Lord Mance's reasoning in Coin, found in the highlighted portions on page 39 of the bundle. Lord Mance termed the test for constructive knowledge as, and I quote in verbatim, a test which relates what actually occurred to natural human reactions given knowledge of what occurred. So in analyzing this, the state of mind of the programmer is not relevant. What is to be considered is the state of mind of the parties when it came to their knowledge that the mistake had occurred. So continuing with Lord Mance's quote, it matters not whether one assumes such knowledge at the time of the transaction or prophetically in advance. The answer is the same. So this means that it is, according to Lord Mance's reasoning, that it is irrelevant whether Miss Rani had kept such a risk in mind at the time of making the at the time of making the algorithm. The answer is the same. If it would at once have been perceived that the fundamental error had occurred, relief should be available. In our case, this would mean that it is irrelevant whether the appellant had actual knowledge of the algorithmic errors when the disputed trade took place or had advanced knowledge of such error. What matters is that when the matter came to the appellant's attention, he ought to have realized as a reasonable trader that only a fundamental mistake could have caused the highly abnormal situation which concluded the sale of Yapple at 250 times greater than the prevailing market price, and the appellant should not be allowed to manipulate and take advantage of a highly unprecedented situation, which was not the fault of either parties, and gain enrichment. This defeats the appellant's contention that he could not have known about the mistake as it took place through deterministic algorithms, as the appellant, as a reasonable trader, ought to have had constructive knowledge. The Singaporean High Court's decision in Ho Sing Lee Construction Pte Limited and Nian Chuan Construction Pte Limited 2001. I shall not be referring to the facts of the case as it is irrelevant to this appeal, but the legal principle found in it can be used as reiterative authority for the above mentioned test. It stipulated that a test for constructive knowledge is objective and must be analyzed in terms of what a reasonable person ought to have known in similar circumstances. This means that what the appellant's actual knowledge is irrelevant. What is relevant is that objectively, any reasonable trader undertaking regular transactions on the Clevity platform, like the appellant, ought to have known that an unusual transaction, like the disputed trade, could only occur due to a mistake, and the respondent would be well within their rights to have the contract declared void for unilateral mistake. Your Honors, in conclusion, the respondent adheres to the view that the Court of Instance did not err in dismissing the appellant's claim by relying upon Lord Mance's reasoning in Coin. The IFC law statutorily accommodates the notion of a non-mistaken party's constructive knowledge within the doctrine of unilateral mistake. For the purpose of Article 37(1)(a), it is sufficient that the appellant ought to reasonably have known that the disputed trade was the result of an apparent malfunction. It is to be noted in this point that the facts state that the Clevity platform went routine upgrades. Routine upgrades suggest that the parties were aware of such upgrades taking place, and such an unprecedented error had not taken place within previous routine upgrades. Therefore, what happened in this situation was one of a kind and unforeseen situation, which was not the fault of either party. Furthermore, it is sufficient that the appellant ought to reasonably have known that the disputed trade was the result of an apparent malfunction. Furthermore, the objective reasonable person test in established case law allows for the imputation of the appellant's constructive knowledge that the disputed trade could only have occurred due to a fundamental mistake, and thus the respondent kindly pleads to the Honorable Court to declare the disputed trade void for unilateral mistake. Thank you.
Thank you. I have just a quick practical question. In case of declaration of the voidness of the contract, which are the consequences?
When a contract is to be declared void, the parties have to be made whole. That is, they have to be put in a position as if the unforeseen situation never took place, and that would mean a reversal of the transaction.
Thank you very much.
Thank you.
I don't know if my co-judge has questions for you.
No questions. No questions from me. Thank you.
Okay, thank you.
Your Honors.
So we can move to junior counsel panel rebuttal. Thank you.
Thank you, Your Honor. For my rebuttal, I would like to point out a couple of things. Firstly, the respondent counsel argued quite a lot on the concept of fair dealing. However, I did not note whether fair dealing was a concept he properly elaborated on. What is the test in this regard is my question. And I see that just like I have, the respondent counsel also gave a lot of credibility to the case of Coin Limited and B2C2 Private Limited. But he only paid attention to the judgment of Lord Mance while completely ignoring, it seems, the other majority judges' decisions. Furthermore, I'd like to point out that Coin, which was cited by the respondent counsel, was a case which found in favor of the party that benefited from the platform error. Lord Mance was one of many judges who found that the outcome should have been different. However, this approach was criticized again by the majority. they argue that it attempted to recast the matrix of facts to suit a hypothetical on-the-floor meeting, whereas we know from the facts there was no on-the-floor meeting. This trade occurred entirely in the absence of human input. Furthermore, the respondent counsel argued on constructive knowledge, which I believe in this case cannot be applied because neither parties were even aware that the formation of a contract was underway when the contract was concluded. Both parties were asleep and had consented to their algorithms trading in their absence. So if Ms. Rani had not wished to enter an unfavorable trade, she ought to have been the reasonable trader mentioned and listed an exception in her algorithm to prevent a loss like this. And finally, I would like to touch upon the mention of the case Hartog and Collins Shields. I believe in that case, there was a error in the pricing of a contract term. The contract was for the sale of hair skins and was to be priced per piece. However, the term stated a pricing per pound. This significantly reduced the price of the contract that the buyers would have to pay to receive the hair skins. They saw this term. The other party was not aware of this term, and they had concluded the trade through that. However, again, this was an error that changed the pricing, and it was to the term of a contract that one party was aware of and the other was not. In this case, there was no contract that either party was aware of until after the trade had been concluded. So I believe that this case does not apply or should not be applicable here, as there was no written contract, there was no meeting in person. There was algorithms that were programmed deterministically, meaning that they cannot learn, they cannot adapt. Their programming follows immediately after they were programmed, and they can only function the way that the programmers had intended them to function throughout their entire lifespan, I guess you could say. That is all.
Thank you very much. I don't have any further questions for the teams. I don't know, my co-judge.
No further questions.
Okay. So I think that we can conclude this round. Thank you very much for all the students, for the participants. Thank you very much to my co-judge.
Thank you.
And, may I ask a question?
Please.
So from the prior meeting that we had before we qualified for the quarterfinal rounds, it was mentioned that the teams qualified through a scoring system. So first place qualified because they had the highest, and then second place, third place, etc. Do these rounds depart from that format? As in, do the judges here decide who wins or loses and then progress, or are we still being graded independently and individually? And the people with the most points at the end of the quarterfinals will then progress to semifinals. Is that the case?
This is a very good question. Let me see if there is something. Okay, I have here the regulation. No, sorry, I don't think.
We can ask the council to turn your microphone off. There's a bit of a feedback. Thank you. Apologies. I don't think that I didn't hear what my co-judge was saying. If anybody else did, I'm not sure.
I will try to jump in. No, I exactly don't know if we can keep the points that you gain until now, or there will be a new list, a total new round. I don't know. But I can ask, and of course we will inform you. Thank you for your question. And I apologize.
It's okay. Thank you for your answer.
Okay, so I think we can we can conclude our session. Thank you very much for both parties and for all four councils. Very impressive on both ends, certainly. Very high level. Definitely, I think it's going to be a difficult one. I hope you had a good time, and it was my pleasure to be here with you today.
Thank you so much.
Thank you.
Thank you very much, everyone. Thank you. See you later, maybe.
Hopefully.
Goodbye.
Bye-bye.